Enemies of the people. Who can forget the coruscating headline? And who, for that matter, can reasonably think that the Attorney General's recent suggestion that the case of the Colston Four could be brought to the Court of Appeal is anything but politically inspired signalling? Apparently, it's no longer judges, but a jury of 12 in Bristol that had decided the wrong way and were now the enemies of the people. It's far too easy to be cynical and suspicious of both the tone and the motives of those who question the role of judges in the UK Constitution, but questioned and debated, it must be. Let me start with a blog written by your own Mark Elliott. It's the final piece in a series he did concerning the report of the Independent Review of Administrative Law. And Mark contrasts two constitutional visions. The first, unrelentingly one-dimensional, Mark's words, emphasises parliamentary sovereignty with, as he puts it, pretty much everything else being at the mercy of Parliament. The second conception sees parliamentary sovereignty as part of a network of interlocking and mutually reinforcing constitutional principles. Mark rightly asserts that the fact these two narratives exist in parallel isn't a weakness, but rather a strength, that the institutions of government hold each other in creative tension is part of the alchemy of the British Constitution. The article is convincing, but perhaps to help make it so, it's also slightly misleading. It takes a rather simplified version of the position the author doesn't like and contrasts it with a far richer vision, which he does. And what's lacking, if you like, is the other straw man. Because whilst those who prioritise politics over the courts are often guilty of simplification, so too, on occasion, are their opponents. So place against the one-dimensional political approach a one-dimensional legal one. According to this, judges are incredibly, perhaps uniquely, smart, knowledgeable and disinterested. They apply the letter of the law, unmoved by their own personal preferences and tastes, and we should therefore be comfortable with them ruling on matters that affect us all, even if, on occasion, they overrule those who we elect. And, whisper it softly, their decisions will generally be wiser than those that emanate from that corrupt den of iniquity, worse, that den of politics in Westminster. Considering the two simplified versions alongside each other perhaps makes us think slightly differently about the creative tension Mark identifies. The legal straw man, and it is a straw man, nevertheless points to some difficult issues that those who support the role of judges must address. First, why should we trust judges? It strikes me that lawyers, like all human beings, approach any issue armed with their priors, or depending on what they happen to have had for breakfast that day. And it's not as if judges are neatly representative of the British people. Only 4% of High Court judges are non-white. The 2011 census put the figure in the population as a whole at 14%. 71% are Oxford educated. 65% attended an independent school. The Sutton Trust in 2019 called senior judges the most socially exclusive group of all the professions that they examined. Now, judges still find themselves amongst the most trusted professionals. 82% trust them to tell the truth. There is no looming crisis in public confidence, perhaps because people get that they need a place to go to challenge decisions that might affect them. Nevertheless, in a world where identity politics matters more and more, the composition of the judiciary and its ability, or rather inability, to look and sound something like the people on behalf of whom it rules is something the profession ought to be thinking about. All the more so because of the second issue. When do judges have the right to decide? What should the limits to majoritarianism be? This issue matters more than ever now that Brexit has happened, because absent EU law, or strictly speaking, in a situation where pre-Brexit EU law can be overturned by Parliament, we no longer have the kind of quasi-constitutional legal structure beyond the reach of a simple parliamentary majority. Yet lawyers, in my opinion, have never done a particularly good job of explaining why some matters of public policy, be it environmental standards, workers' rights, human rights and the like, should be treated as questions of law and not as matters for political debate. I think partly this was, under the Ancien Regime, down to a mixture of hubris and laziness. Hubris because, while the UK was a member of the EU, and while friendly politicians were in charge, it was taken for granted that certain rights could not be altered by Parliament. Laziness because this situation meant no one bothered to argue the case, to explain why majoritarian politics should have its limits, where those limits should lie, or why environmental or workplace regulations should be set in the way they were. This lack of clarity in turn created the conditions for the charge, whether it's fair or not, that the courts were guilty of engaging in politics by other means. The paradox is that it might only be by making the case for judicial review in clear and simple terms, in effect by acting more like politicians, that the courts can avoid that charge of judicial activism. We live now in a different world. The era when experts, technocrats, and yes, lawyers ran things was the world so successfully challenged by the slogan of taking back control. Yes, it was about the EU, but it was about much more too. This was a system many thought had failed them. And while I'll leave it to you lawyers to discuss the intricacies of judicial review, let me remind you that it is not ultimately lawyers you will need to persuade. Rather, it is others less convinced about the sanctity of your profession, or the fact that it is law and not politics that determine how our country works. Thank you.